Hello and welcome to Short
Circuit.
Yes, this is Short Circuit live from Antonin Scalia Law School in Arlington, Virginia, George Mason University. This is the first time that Short Circuit has been here live at Scalia Law, and we are so happy to be here. Thank you for the Federalist Society chapter at the school for inviting us. We have a full set of panelists to discuss some recent cases, and they are from the D.C. Circuit. So we will introduce the panelists in a moment, but first I just want to say a little bit about the circuit that we are focusing on here today. So the circuit, of course, is right across the river here from Scalia Law in Arlington, Virginia. In fact, we used to be part, right, of the District of Columbia a very long time ago, and so we would have been part of the D.C. Circuit if it had existed before the Civil War. I don't think it quite existed at that time, but it is, as they say, that the nation's second most important court. I don't know if that's true or not, but some people like to say that. And it focuses a lot on administrative stuff to do with the federal government. And so one judge I heard years ago told a story who was on the D.C. Circuit that the judge was on a panel, and it was one of these rare cases where it was like a normal just diversity jurisdiction case. So I don't know if it was a car crash or whatever, but I think someone from Maryland or Virginia happened to be involved with someone from the district, and so they were there and just doing, a normal law stuff like a state court would normally do. And so one of the judges afterwards said, "Don't you love these diversity cases? It makes you feel like a real judge." And then the judge I was talking to said, "What? Yeah, no, it terrifies me. Like, we're not real judges. This isn't a real court." And so the kind of back and forth there is just that the D.C. Circuit deals with certain special things, but it is also, like it or not, a real court that has real jurisdiction over all kinds of matters, including the ones that we're going to talk about today. And the ones that we're going to talk about today are the more that you might expect from the D.C. Circuit with some very important and breaking things. So if anyone wants to get really into the weeds in the D.C. Circuit and Short Circuit, we did a Short Circuit Live a few years ago that focused on like clerking at the court and those kinds of things. And so we will put a link in the show notes, as we always do, to that past episode. And I invite listeners and the people here today, if you go on our website or on Apple Podcasts or whatever, you will find that link. We had Lisa Blatt, Paul Clement, and Casey Cochran from Georgetown on that panel. But today we have other distinguished guests. So here I have next to me Professor Todd Zywicki of George Mason University. He is the George Mason University Foundation Professor of Law. He has done so many things that we're not going to take the time to name very many of them, although I think particularly for what he's going to talk about, he at one time was director of the Office of Policy Planning at the Federal Trade Commission. That was back in the Bush II years. He also is a wonderful helper with people getting involved or students and those who are younger scholars. Todd did an incredible thing to me earlier in my career, and when I was talking about what scholarship I wanted to pursue. I was a very young lawyer, and he had this manuscript sitting around. He said, if you finish this, then I'll put my name on it and we'll publish it together. And somehow I got across the goal line, and we got this article. It was about Friedrich Hayek and Judge Posner, and we got it published, and that has paid so many dividends to my career. And so, Todd, thank you for that, and thank you for everything else you've done for so many young scholars. So Todd will be speaking in just a moment. After him, we're going to hear from Casey Norman. So Casey is an up-and-coming litigator who is litigation counsel for the new Civil Liberties Alliance, where she does all kinds of various things suing the government. And we have a special place in our heart right now for NCLA because they recently won the the first Chip Mellor Prize for Excellence in Public Interest Litigation. That was just earlier this year. That was for their role in overturning the Chevron doctrine. And for those of you who have known about IJ for a long time, that is named after our late co-founder and longtime president, Chip Mellor, that is not even going to be awarded every year. It's just awarded when it is warranted, and it was warranted this year. So we are very pleased to have Casey here. And then finally, at the end of the table, speaking later, is my good friend Bob Belden, who is at the Institute for Justice with me. He is a co-director of our Zoning Justice Project, and he does so many other things for IJ. So we will hear from all of these fine people a little later, but most immediately, Professor Zywicki, and he has a couple things you may have heard about in the news. There's these employees getting fired by their boss, but is he their boss? Can they be fired? And this matter has gone to the D.C. Circuit. It is now at the Supreme Court, but we're gonna talk about the whole kit and caboodle, and that is Slaughter v. Trump and Cook v. Trump. So Todd.
All right, thanks, Anthony. And Anthony is too modest. It was great writing that article with him many years ago on Hayek and Posner, and it's been great to see you go on to become a real lawyer rather than a professor who just talks about stuff. You're actually doing stuff, so good work. I'm going to talk about the Cook and Slaughter cases, Cook being the Federal Reserve Governor, Slaughter being the Federal Trade Commissioner. And Anthony mentioned that I spent 20 years or so ago time at the FTC, but I also, during Trump 1, during 2020, I worked at the CFPB, Consumer Financial Protection Bureau, and right around the time that the Scalia Law case was decided, which we'll talk about probably a little bit here. And so I've got a foot in each camp. I've got a foot in CFPB's a bureau of the Fed, so I guess I've got a foot in both the FTC camp and the Fed camp. And the reason I pick these cases, even though in some sense they seem obvious, everybody's heard of them, perhaps more than the other cases. The reason I pick these cases and what I think is interesting about them is the litigation posture that the Trump administration is taking in the two cases is very different. And we can speculate on maybe why that was. But I think it's worth sort of looking at these cases because most of the coverage, sort of the top line coverage is sort of along the lines that Anthony just said, right? Trump wants to fire the members of these so-called independent agencies, the Federal Trade Commission, the Federal Reserve. Before that, the Merit Systems Protection Board, or whatever it's called, various Consumer Product Safety Commission, I think. Anyway, a bunch of these independent agencies. These are the ones that have kind of percolated up to the surface. So Trump fired, just out of the blue, Rebecca Slaughter and Bedoya, who is the other Democratic commissioner on the FTC. Slaughter has litigated this. Bedoya just chose to retire. So she's the only one who's still a party. And she's been in and out. She got fired, and then it got stayed, and then she came back to work for like a day or two, and then the D.C. Circuit lifted the stay, right? Appealed to the Supreme Court. The Supreme Court has stayed the decision of the D.C. Circuit that we'll talk about, so maybe I got the details wrong there, right? But they basically said, you are out for now. They stayed her desire to be reinstated based on the D.C. Circuit opinion. Apparently I got the timing backwards, but she's out. Cook was also fired by Trump from the Federal Reserve. She's the one in the Federal Reserve who's been fired. D.C. Circuit also opposed that. It's kind of, from what I understand, I'm not a procedure guru, so you guys clarify. But the D.C. Circuit, but the Federal Supreme Court did not stay that order, but they essentially just took the case on expedited appeal. So as I understand it, she is still there, but they're going to hear the case very promptly, and I'm not sure exactly when it was. Right? So we got these two cases. Superficially, they look the same, right? One with the FTC, one with the Fed. In both cases, the DC Circuit said you can't do this. In one case, the Supreme Court said, for now you can, right? Slaughter is out while we hear the appeal. In the Fed, they said, for now, she can continue to serve, right? So what's going on in these cases? Why do I think these cases are interesting to talk about? And in particular, what is it that I think is not obvious about this to somebody who hasn't read the cases? As I said, the Trump administration is pushing very different theories in these cases, although both of them are designed, obviously, for Trump to bring control over the administrative state. They're pushing different theories. So in the Slaughter case, the Supreme Court, the FTC case, the Slaughter case, the Supreme Court is saying that with respect to the Federal Trade Commission, both of these agencies have so-called for-cause removal provisions, right? That's the nature of an independent agency. They differ a little bit from agency to agency, but basically what it says is you can only remove for cause, including neglect, malfeasance, dereliction of duty, and the like. In the Federal Trade Commission case, the Trump administration is arguing the for-cause removal provision is unconstitutional. That under a Supreme Court precedent, when an agency exercises executive power, a lot of executive power, then the president has to be able to remove that person at will, right? Invoking the so-called removal provision of the Constitution. Now, of course, there is no removal provision of the Constitution, it turns out. That is been found in the Constitution, the structure of the Constitution, in the power of the president under Article 2 to exercise the executive authority. The gravamen of that has basically been to say that the president needs to be able to remove executive officials so that the president can efficiently administer the laws. Now, one question that never has been addressed, or rarely has been addressed, according to all the people I talked to, is why are bipartisan appointment provisions okay, right? I'm not sure that this has really ever been litigated in a serious way, which is why can you restrict the ability of the president on who he appoints, but not on who he removes, right? Which is sort of an odd a question, but we could set that aside. But in that case, the Trump administration argued either that for-cause removal is unconstitutional, and what they talk about Humphrey's executor, it's not quite clear whether their position is Humphrey's executor was unconstitutional when it's first decided, or whether or you could still keep Humphrey's executor, but attack the modern FTC on the basis that the FTC of today is not like the FTC of Humphrey's executor. And if you recall, Humphrey's executor was a 1930s case where Roosevelt was annoyed at the Federal Trade Commission, told this guy, Humphrey, you're fired. Humphrey said, no, I'm not. Eventually, Humphrey passed away during the litigation, which is why it became Humphrey's executor, which we'll come back to in a moment, and went up to the Supreme Court, and the Supreme Court held that independent agencies were constitutional because they like the FTC, because it exercised quasi-legislative and quasi-judicial authority, implying that it didn't really do any executive authority. And so as a result, these bipartisan expert commissions were quasi-judicial, quasi-legislative, and quasi-constitutional enough, apparently, right?
I got a question just to poke in here. When you were at the FTC, did you feel like you were more doing executive stuff, legislative stuff, judicial stuff? What did it feel like?
It was...
you weren't a commissioner, of course.
I wasn't, but I would say the sense of the place, it was all three. That it really was all three. And I remember the first day I showed up at the FTC, and I wasn't an FTC jock, and I hadn't litigated there in practice. I was there because of my knowledge of competition law, consumer protection. And they explained to me how the FTC resolved disputes. And so I don't know if you know how this works, but when the FTC finds somebody they want to sue, they conduct a preliminary investigation, and then they go out and the 5 commissioners swear out a complaint against the company, the wrongdoer. And then they pretend like they've never heard of the case again. And they create like a Chinese wall within the agency where the case gets prosecuted, tried before an administrative law judge. And guess who they appeal the decision of the administrative law judge to? The FTC. Right? So the FTC swears out the original complaint and then pretends like they've never heard the case, right? Guess what the win rate of the FTC is on these cases? Regardless of what the administrative law judge decides, the FTC always decides that the person is liable, right? And there's empirical evidence that supports it. Right? And so this was explained to me, and I was like, really? That can't be right. I was like, to explain it is to understand why it has to be unconstitutional, right? There's no possible way that can make any sense, right? But we also did major rulemaking when we were there, which was quasi-legislative. Obviously, that was both executive, right, imposing sanctions, as well as judicial resolving the case. And so, and I guess people just kind of get used to it being all of these, right? But back in the day, and so a lot of this is turned on. What did the FTC actually do in the 1930s? And they did do a lot less, and they had a lot less than they do now. Some of the fighting is, are they really that much different than they were then? But that was the logic of the Humphreys case. It stood in that linchpin that they were not exercising executive authority, which allowed them to get around the Myers versus United States case, which had been decided right around that time, that logic right around that time. So that's the backdrop here. So the Trump administration seems to be, they could decide this case by saying the FTC today is different from the FTC in the past. They hinted at this in the case of Scalia Law, which struck down the for-cause removal provision on the CFPB director a couple of years ago, and they hinted that one basis for going after the FTC today would be going after this. They actually had a case the next term called AMG, where I thought that they were teeing up. AMG was this case that involved some sanctions that the FTC wanted to pose on a party under the statute. What the Supreme Court ended up doing was ducking that and basically saying the FTC did not have that authority to pose those sanctions under the statute. I thought they were teeing up a challenge that would have basically said the FTC could impose those sanctions, but therefore it's unconstitutional. But the Supreme Court stepped back from the brink in that case. So now it's being confronted directly. But in that case, the Trump administration is arguing for-cause removal provisions for the FTC, at least as it's currently constituted, are unconstitutional, as well as any other agency that exercises executive authority, a substantial executive authority, which basically includes the entire administrative state today, except for one possible exception. What is that possible exception? Now we got the Fed. We got the Cook case, also for-cause removal. What are they arguing in the Cook case? What happened in the Cook case is President Trump, as we know, has not been happy with the Federal Reserve and their actions on interest rates, and has been wanting to get his own people on there because it turns out there was a scheduled vacancy for next year, and I think it was going to be a while after that before going to be another scheduled vacancy. One was created when somebody suddenly resigned. Trump put somebody in that seat. Resigned early, and so Trump put somebody in that seat. But what happened in Cook? So Cook, if you've been following the news, has been alleged to have engaged in mortgage fraud, which is also tripped up Letitia James, the Attorney General of New York. But Cook has been accused of engaging in mortgage fraud by the FHFA commissioner. Trump used that to say that provides cause for removing her from her position at the Federal Reserve. And so note, he's not arguing that the for-cause removal provision is unconstitutional as applied to the Fed. Instead, they're accepting for purposes of the case that the for-cause removal provision is constitutional, but that the president gets to decide what cause means. Right? And he has decided that public confidence would be undermined by having somebody who's alleged of mortgage fraud serving on the Federal Reserve, since the Federal Reserve regulates banks and others who do mortgages and various other sorts of things, right? And so Why is that? Well, in an earlier case, the Supreme Court had, out of the blue, on an earlier case involving some of these cases, the Supreme Court had tipped their hat and said that executive agencies may be, or independent agencies may be unconstitutional, except for maybe the Fed, right? And the Fed may be different, right? Because everybody's freaked out. What's going to happen with monetary, right? What's going to happen with monetary theory in the Fed?
And it hit right. It might be different because it's kind of more private, which to me sounds worse.
Yeah, right. Yeah, and so I think there's a colorable way in which this all might make sense. And how there's a couple ways this might work its way out in the Supreme Court, and then I'll turn to my colleagues, right? Which is, first, as Anthony just said, what the Supreme Court said in that case is that the Fed does not exercise executive authority. I think that's arguably correct as it comes to the Federal Open Markets Committee, right? The monetary policy stuff, which is what everybody cares about with the Fed, arguably may not be executive power, right? What's ironic is the more people tell me that the Fed needs to be independent, the less I think they should be independent on monetary theory, right? They're basically, oh, this is too important to leave the democratic process. And I'm like, is that really the argument you're making here, right? But it's not clear what it is. But there is an argument they could make that would save the Fed. Monetary policy theory, which is one argument that they've hinted at is the Fed is basically private. It's like the first and second banks of the United States. And within this tower of sort of separation of powers in independent agencies, the Supreme Court has said there are well-established exceptions that could be perpetuated that are just accepted as ad hoc exceptions. The first bank of the United States, the second bank of the United States, and the Fed monetary policy, which was more like what the first and second banks did, right, is like that. There's a whole nother side of the Fed, though, which does clearly exercise executive authority, and that is the supervisory and enforcement powers of the Fed. So one possibility that is being teed up here would be that what everybody cares about, which is the monetary policy, might be saved, and the supervision and oversight might have to be under greater presidential control. I don't know how they would do that. However, one thing I can say with confidence is that John Roberts is not a man who's particularly concerned about intellectual consistency. So if it comes down to Roberts just making up some distinction between them, I think that's on the table, simply to get the result that the Fed will not overturn the apple cart. One last question, and then I'll turn it over. What is the remedy here? So let's go back to our poor Mr. Humphrey, right? Why was the case Humphrey's executor? Humphrey sued, he then died. What went to the Supreme Court, obviously, was not an injunction, because Mr. Humphreys could not be enjoined, put back in his seat at the FTC, right? Weekended Bernie's one, right? Weekended Humphreys or something, right? So the case was actually teed up as a case for back pay for being fired wrongfully. Judge Rao's concurrence, and we may come back to this, Anthony Tippett, Judge Rao's dissent in the D.C. Circuit said, well, even if Slaughter has a case here, she gets back pay, right? The precedent says she gets back pay, not reinstatement, right? And there's a variety of other reasons why she says that, right? Now, that may be the precedent. I find that, and what the Supreme Court said was, in the FTC case, the harm from from allowing her to sit would be greater than the harm from excluding her. The harm from allowing an unconstitutionally appointed person to participate in decision-making is a greater harm to the public than if she can't participate, right? Whatever that means, right? But what I would say is, whatever for-cause removal means, I find it really hard to believe that all this fighting and all the reason that Congress did it was simply so that somebody wrongfully removed could get back pay, right? Whatever it's about, that can't be what it's about, is somebody getting back pay. That may be the precedent, right? But the weakness of that precedent may say something about the weakness of the entire case and the stability of those precedents. So That's what I got to say.
All right. Well, Casey, you and your colleagues at NCLA do all kinds of litigation against executive overreach, and I'm pretty sure you ask for more than just back pay in those cases. So, tell me your thoughts on that, whether about the last comment or anything else.
Yeah, I mean, I think first I'll just say that Humphrey's Executor, when I was a law student, like that was not a sexy case. I don't think I even remember learning about it. And so, I mean, it's interesting because over the years I haven't thought about it once until this year, and now it's becoming sexier and sexier and interesting. And I don't think I have a firm opinion yet about what is the clear answer here. I think either this is a really complicated question or not at all. And I think people who believe in the unitary executive see that Article 2 vests all of the executive power in the president, period. So if any entity like an agency or official is exercising any form of executive power, he should be able to remove that official. And I think, that's probably the simplest approach, but then you have all these questions about the Federal Reserve. Is that so important that we have to maintain stability and the president can actually control it, even though it does exercise some semblance of executive power? And that gets complicated for me, and I don't know, this whole for-cause removal question, I think, is an interesting one, especially in this context, because the government doesn't dispute the for-cause thing with the Federal Reserve, where it does with other things like the FTC, CPSC, and these other agencies. And one, it's not quite clear to me why. I know the Federal Reserve is important, but a lot of these agencies are, and they wield a lot of power that can impact, the entire nation, the entire economy. They make policy. And so I don't know if there's a principled way to really, if they're going to get rid of Humphrey's Executor, how do you distinguish the approach, vis-a-vis the Federal Reserve versus all these other agencies? But also my question with the for-cause removal element is, if the government's right, like in what they're arguing in Cook, that we can just put forward a cause, the president can make up a cause, remove this official, there doesn't have to be process, because the whole argument in that case is that she didn't receive due process before being removed, like notice and the opportunity for a hearing and that kind of thing. But if that is not due to an official, I don't see what the difference between for-cause removal is and at will, because a president, in theory, you'd think could just make up a cause and no one's going to investigate it. There's not going to be a hearing. So that element of that case, I think, struck me as kind of the most curious, if the government is right.
Sounds a little bit like the rational basis test to me.
Yeah, a little bit like that. So unfortunately, I don't have a firm answer on this, because I'm still trying to wrap my mind around everything that's going on. Todd probably has more insight than me, especially with respect to the Federal Reserve, and like, how do you actually, in a principled way, distinguish that from like the FTC and these other big agencies that.
Well, I think, and it reminds me, I don't remember the exact quote, so I will get this wrong, but I think it's a recent British Prime Minister basically said that the only entity with true sovereignty in today's world is the bond market. And so this all comes down to the bond market will win. Right. And so we need to acknowledge that.
That was James Carville's famous line, that when he's reincarnated, he wants to come back as the bond market.
That's right.
Because he'd be the most powerful.
So, Bob, your thoughts about, you don't have to get into stocks and bonds, but
no, I
how to make sense of this.
A sort of, the shadow docket and the emergency docket is kind of a hot topic now. And Professor mentioned the Slaughter case, the Supreme Court granting the stay. And I think Justice Kagan is a great writer. And I read her dissent from the grant of the stay, and I thought it was quite punching. I'm just curious if you guys read it and if you have any thoughts about whether it portends anything on the merits, because it seems like she makes a pretty straightforward argument, like this is the same agency, same issue. If our precedent means anything, maybe it means we should keep this stay in place while we decide the merits, the district court order. So I'm just curious if you have any thoughts about that issue.
Yeah, I mean, I think, basically her point is if you're not going to grant the stay, you're essentially overturning Humphrey's Executor without proper briefing and oral argument, right? I mean, which I think is a valid argument. One of the things that's interesting about Kagan more generally, she pulled this, this is the approach she took in the Dobbs case, among others, is she has this theory where she's trying to bootstrap stare decisis on all these things, right? Which is, Kagan seems to have adopted this strategy that simply says, we can't relitigate abortion because of stare decisis. We can't relitigate the administrative state because of stare decisis, right? And there's a sense in which her defenses of the original opinions are kind of half-hearted, and she's making these stare decisis bootstrapping arguments, which so far have had zero success from what I can tell, right? Because I think the Supreme Court generally, especially the Supreme Court with 6 like-minded justices in either direction, is not going to feel very bound by stare decisis, right? And so she makes that argument. I think it's a valid argument. But basically, the way the Supreme Court has dealt with that is simply say, we're going to just take these cases up really quick, right? And so we're going to resolve this, and everybody knows how we're going to resolve this. It's just a matter of the details, I think.
So one area where there is quite a lot of stare decisis, of course, is in the First Amendment and free speech. But even there, sometimes you can see new arguments, new issues percolating, and courts sometimes go along with that, and sometimes they don't, which is why we're now going to FBI versus Hedridge. I'm probably maybe pronouncing her name wrong, but it is about a reporter and reporter's privilege under the First Amendment, and this is a recent D.C. Circuit case that Casey's going to tell us about.
I think it's Herridge. I'm just going to say
Sorry.
Herridge. I might be wrong, but if you
Been a while
say that,
since I watched a lot of TV news. So.
Yeah. So just to introduce the kind of the core context and the main issue that arose in this case, let me just start with a scenario here. Imagine that the federal government has quietly opened an investigation into you. Maybe you're an immigrant who became a citizen in the United States. Maybe you work for the DOD, whatever it might be. But you wake up, you go online, you see, say on Fox News, which is the entity at issue in this case, that there's this damning article about you. It's talking about how you may be a spy, the FBI is investigating you, there are family photos posted and information that you have no idea how it could have gotten in Fox News' hands. And it just splashed across the internet. So that's essentially what happened in this case to the plaintiff, Yanping Chen. And at bottom here, the case really kind of grapples with 2 fundamental legal principles in this country. The first one being the First Amendment right to a free press. And the second one being the protection of individuals' rights to privacy, especially when the government is committing misconduct and it's kind of the root cause of your private information being publicized or disclosed. And the big question for the DC Circuit in this particular case was when a plaintiff or an individual like Ms. Chen in this case sues the government under the Privacy Act, which we'll get to in a second, because the government's essentially leaked private information to the press, can that plaintiff compel the news organization or the reporter who published that story to reveal who it was who leaked the information to them, particularly in a case like this under the Privacy Act, which deals with the government being the source of the leak? So not to bore you too much with statutory information, but just to give a little background on the Privacy Act for those who aren't familiar. I wasn't actually until I read this case. It essentially was a response to the Watergate scandal back in the day, and also a response to the increasing usage of computers and government collecting information about people online, and just this fear that there could be abuse of information and that government could potentially harm people by leaking it or accidentally disclosing information that they shouldn't. So the Privacy Act essentially just prohibits government agencies from disclosing information about individuals without getting prior consent from the individual first. And there are certain exceptions that aren't really applicable here, so I will spare you from that. But essentially, a plaintiff can prevail on a lawsuit under the Privacy Act only if it can show that the government acted willfully or intentionally in this disclosure. It can't just be, like an innocent error or something like that. And if they can show this, then they can get actual damages, meaning concrete financial harm that they can show, plus attorney's fees. So the issue in these kinds of cases is evidence. You can't really show that the government acted intentionally if you don't really know how the leak happened, who it was who leaked the information. So that's kind of where we get to this reporter's privilege, because in a case where the government intentionally broke the law and leaked information it knew it shouldn't have, it's pretty unlikely that the government is going to come forward and be like, that was me, that was my bad. I will take the repercussions. So really, like, the only option a lot of these plaintiffs have is going to the news organization, the reporter who published the story, and because they obviously know who had that information and provided it to them. But then you run into the First Amendment and the freedom of the press and the fact that we like our press to be able to, have relationships with informants and, confidential sources who will provide important information for, American citizens to read. And we don't want that to be chilled. We don't want the press to be cut off from sources like that. And sources may not come forward if they think that their identities will be revealed in courts like this, if they're compelled to reveal these secret identities. So basically, after a Supreme Court case called Brandsburg v. Hayes back in the 70s, this is when the privilege kind of started to take existence. I don't think that's a phrase. Came into being. There we go. That context had to do with a criminal proceeding and a grand jury, and the court basically said there is no privilege for reporters not to disclose criminal information or confidential informants when we're talking about, a criminal investigation in a grand jury. But it pointed out, there is a First Amendment interest here. We want the press to, whenever possible, we want to maintain their First Amendment protection. So keep that in mind, courts. Don't be too overly zealous about making the press reveal the confidential sources. And so in the decades after that Supreme Court case, I think almost every single circuit court across the country has recognized some form of qualified privilege for reporters in contexts like this, where, there's a question of do they have to reveal their confidential source or not. I think only the Eighth Circuit still leaves that as an open question. But there are not, I think DC Circuit, this may be one of the few that has to do with the Privacy Act context. And of course, DC, you have a lot of these kinds of lawsuits because this is where government sits, this is where the agencies are. So in the DC Circuit, there are basically two kind of core governing cases that determine what do courts do when you have a Privacy Act claim by an individual against a government agency, and they're claiming this government agency, someone in the agency leaked information about me and I've been harmed and now the press is all over it. And I can't get the information that I need from the government because they're not going to tell me. So I need to subpoena, someone within that news organization and figure out who did this to me in the government so that I can get my damages. So in a case called Zywicki v. DC, this was a Privacy Act lawsuit against DOJ officials who had leaked information about this. I don't know if this is true, but it was alleged that the plaintiff, Zywicki in this case, was a mob boss in Detroit. So the information kind of ended up being in the Detroit news. They were talking about how he led the Detroit mob, and it was very damaging, obviously. So basically, through this case, the court came to the conclusion that for the privilege, to determine whether the reporter's privilege applies or not, and whether the reporter has to reveal the identity of the person in the DOJ, in this case, who revealed this information to the press, you have to consider two things. One is cruciality. Is the information that the plaintiff seeks to compel from the reporter, is this information crucial to their case? Is it going to win it or not? Or is it just kind of corollary? It doesn't really matter either way. So that's the first consideration. And usually in a Privacy Act case, it's going to be crucial because you need to know who in the government revealed this or leaked this information to prove intentional or willful disclosure. And the second consideration is exhaustion. So did the plaintiff exhaust all reasonable alternatives of sources of information first before turning to the press, getting into that tangled weeds of First Amendment, the press's rights to maintaining their relationships and their bond with their confidential informants and all of that kind of thing. In this case, the plaintiff was pretty ridiculous. He basically took the DOJ at their word. They said, we don't know who the leak is, sorry, we can't help you out. And the plaintiff thought he could skip the exhaustion requirement by just saying, okay, DOJ, I believe you. So now I'm gonna go to the news organization. I need to subpoena everyone there and I need to figure out who the leak was. And the court was not having any of that. They said, we're not gonna mess with the First Amendment before you've even tried to, talk to the DOJ. The DOJ, in fact, had given a list of people within the agency who had, worked on this investigation into this alleged mob boss man, who may or may not have had, inside information about anyone who talked to the press about this. So the court basically ruled, it basically left open the question, if this plaintiff had exhausted all alternative sources of information, would the privilege apply or not? And they kind of left that question for another day. So then you have a more recent case, Lee v. DOJ in the DC Circuit, which is basically the same facts, but in this case, the plaintiff actually did his work. He deposed a ton of people within the government agency who he thought had leaked the information at issue. And so the court there held for the first time, I think in the DC Circuit, that even though in a case like this where the press entity is not a party in the lawsuit, we can still compel the press to disclose who the confidential informant was, because this is crucial to the plaintiff's case. And this plaintiff worked really hard trying to get the government to tell him who the leak was, and they didn't really comply. And after 40 depositions, nothing was clear. So we're going to go to the reporter and just ask, because obviously the reporter knows. So then we get to this case, and I'll give you a little factual background just so you have a picture of who Yanping Chen is and how this all came about. But basically, she was born in China. She came to the US in the 80s and went to George Washington University here, got her PhD there. She ended up being a lawful resident of the US, and then she actually opened a university that's like right down the road from us called University of Management and Technology. And then she became a citizen of the United States in 2001. And crucial, which will become apparent in a moment, is the fact that this university that Ms. Chen founded received subsidization from the DoD, and they would subsidize portions of military service members' tuition, so that attracted a lot of students who were, in the Army and the military. So anyway, in 2010, the FBI began to investigate Ms. Chen. They had seen her immigration, naturalization forms. They thought she may have lied about some of her statements for whatever reason and hadn't disclosed the fact that she had espionage connections or, was a former Chinese military official. I think her father had been in the Chinese military. So they started an investigation, which they conducted for 6 years. They got search warrants. They searched the university. They searched her house. They took, family photographs. They interviewed her mom, her daughter. Very extensive investigation. And after that 6 years of investigation and toil, she was informed that no charges would be brought against her. So she thought she was in the clear. Unfortunately, she was not, because I believe about 6 months later, in February of 2017, Fox News published first of a series of investigatory reports about Ms. Chen that basically detailed the FBI's investigation. They had photos from her home, like family photographs posted of her father in a Chinese military uniform. They had, FBI confidential memoranda that detailed the FBI's investigation and why they thought she was a spy. All these things that clearly were not public and that, clearly couldn't have really been gotten other than from the FBI and the team that was involved in the investigation, or someone who had a connection to the investigative team. So Ms. Chen decided, well, first I should mention, because of all of these reports, accusing her of being a spy and in the Chinese military, her university, UMT, was cut off from the DoD's funding, which, really, really impacted their revenue. A bunch of service members, students who had been attending dropped out, and she wasn't receiving new enrollment from members of the military. So, both her reputation took a hit, the university's reputation took a hit, and the revenue that they were receiving was very starkly, impacted by this. So she filed a Privacy Act lawsuit against the FBI and I think one other agency, the DOJ maybe, who had been involved in the investigation against her. And very similar to the cases that I described before, Zerilli and Lee, she took all these steps in the discovery process. She deposed, I think, 22 people. She sent out, dozens of interrogatories and requests for declarations from all these people in all these, in the FBI and the DOJ. And after, I believe it was 4 years of discovery, which sounds horrible. Once you guys start practicing, you'll know. But at 4 years, she came up with nothing. She could not figure out who in the FBI had actually leaked this information. And, at that point, she said, I need to subpoena the Fox News, the reporter, Catherine Herridge, or Herridge, whatever her name is, to find out who the leaker is, because otherwise she couldn't get damages, she couldn't prevail. So Catherine Herridge and Fox both, objected to this. They said, we have a First Amendment reporter's privilege. We don't have to reveal anything to you. Sorry, we're not going to. The district court said, yes, you have to go to your deposition, tell her, and they refused. So the district court ultimately held, okay, Fox, you don't have to answer yet. We're just going to focus on this individual reporter who published the story. You do have to answer, or else you're going to be held in contempt, which she was because she continued to refuse. So that's how this case basically got up to the DC Circuit. And interestingly, this reporter, Catherine Herridge, she did not dispute at all the cause or the cruciality or centrality exhaustion test that I described before about the two considerations a court has to look to see whether the reporter's privilege applies or not. Catherine Herridge said, I don't care. This might have been central to Ms. Chen's case. She might have exhausted all of, alternative options or sources of information. But I'm in the press, and, publishing a story about, a potential spy is more important than any individual's privacy rights. So if you should do a balancing test, and if you do a balancing test, the press's rights win every time. I don't know why you're doing this. So the court, first of all, said, no, that the DC Circuit precedent is very clear. We're not just going to do this ad hoc balancing test. The DC Circuit has said in multiple cases now, look to centrality and exhaustion. Those are both met here. And we're not going to just do this balancing test, which jeopardizes individuals' rights. And of course, we still value, the press's protection of their sources. But, the centrality and exhaustion, those aren't really easy. They're not just checked off the list. I mean, for Ms. Chen, she had to go through 4 years of discovery, really put forth a lot of effort before making it to this point. And then, of course, there's also the federal rules of evidence and procedure, which have additional protections, like, evidence has to be relevant. And even if it is relevant, you have to look to the probative value versus the prejudice and all kinds of things like that are built in that aren't just leaving journalists completely helpless if we don't do this more forgiving, kind of generous balancing test that this reporter here wanted. So essentially, and she had also argued that Ms. Chen's, the Privacy Act lawsuit was frivolous because Ms. Chen had said that most of the damages she suffered had not actually been because of the leak. It had been because of the independent decision, supposedly, of the DoD to cut off funding, which I don't know how reasonable the characterization of independent here is in this case when you read a series of reports saying that DoD is funding a Chinese spy in the military. How dare they? Because one of the anonymous sources cited in this article was somebody in the FBI who had said it's an outrage that the DoD would do this. This is counter to American safety and interests. And the court very, very squarely rejected that argument and said, even if this was an independent decision, even if most of the damages were from this independent decision, if some of the damages were from this leak, then you have a cause of action and you can move forward, even if your damages aren't going to be that great. So ultimately, the plaintiff did prevail in this tentatively. The DC Circuit has said, you are able, or Ms. Herridge needs to disclose the identity of the leaker here. So fingers crossed that Chen, the plaintiff, prevails on that, and we'll see what happens. But I mean, the bottom line is this case and this investigation have gone on for years and years of Ms. Chen's life, and she could win $1,000 of damages ultimately. It's very costly to go through litigation and then at the end of it have to prove your actual financial losses, and if you can't, then you're kind of at a loss here. So I think for me, this case is really interesting because I think the DC Circuit got it right in terms of stare decisis and applying the tests that had been set forth in prior precedent. But I think it also leaves plaintiffs in Privacy Act lawsuits really exposed because the burden's on them. I mean, you have to go through, again, in this case, years of discovery, depositions, declarations that cost a lot of money, a lot of time, a lot of fortitude for someone, and then ultimately not get answers and then have to deal with this whole First Amendment tangled situation. And it seems to me that maybe a better solution would be to shift the burden more to the government in terms of, they are the ones who have the resources, who know how their record systems work. Maybe if a plaintiff could lay out, a basic, over a preponderance of evidence case that says it's pretty clear that this information came from the government agency, and then shift the burden to the government to prove that, it was an innocent mistake.
I mean, someone in the government leaked this.
Yeah.
So someone in the government knows who the leaker is. And it does seem I've been through plenty of times asking for various levels of government to give up their, information or data. It is a lot harder than deposing a reporter.
Yeah, that seems to be the case.
Yeah. Bob, your thoughts about this?
Yeah, I mean, I think there are a lot of competing interests at stake. I think that there should be some scope for, drawing different or creating different rules. Like if you're a private individual trying to figure out who leaked this information, I think you ought to face a different showing than, like, for example, if the government is trying to figure out who leaked information. It's just something that occurred to me as I was reading it. It does seem like very onerous for a private individual to figure out who ruined their life, you know? I also thought that it's kind of an interesting quirk in the DC Circuit law that you're more likely to get to pierce the privilege if you're also bringing a libel claim against the news organization. And so I thought, like, you know, why not just sue everybody and claim it's a libel? And, like, if you're not sure if it is or not, say on information and belief, I'll find something in there that you should have known meant your reporting was untrue. But a very interesting case, and, you know, I hope she's able to figure out who did it.
Any thoughts you have, Todd?
Yeah, this case is interesting in that, as Bob was just saying, I think it's applied. There are some real line drawing issues here, right? You can imagine things at one extreme end and then others that may be the other end. So one end, obviously, something that is a leak about something is purely public. You mentioned Watergate, but I'm thinking like the Pentagon Papers, right? Where they're leaking specifically on an issue of government policy to a reporter. I have no problem upholding a reporter's privilege in a case like that, right? I mean, you could raise questions about national security, maybe, things like that. That might make it more complicated. But things that go directly and purely to public policy seem to me to be on one end. Then when it comes to private parties, on the other end, you might have something that seems obvious to me, like during the Obama administration, where IRS records were repeatedly leaked to activist publication and activist groups about nonprofit organizations, clearly with the intent of somebody to target those organizations, right, for boycotting and cancellation, all that sort of stuff. And that really happened, right? People lost their businesses, for example, because they thought they had made confidential contributions to groups, say, for the California same-sex marriage referendum. That got leaked, and as a result, they basically had their businesses boycotted. Direct damage caused from that, right? Then you get cases that I think are on the line, like the leaking a little bit that and there's no public interest right there involved in just massacring somebody's opinion so that, you know, private parties will jump on them. Maybe one of the cases that's on the line was the case a few years ago where somebody leaked the tax records of really high income people, right, to show how they use tax loopholes and stuff like that. I tend to think of that as being somewhat frivolous, right? That would be a good explanation to leak people's private records. This case, I find to be a little bit difficult, right? From the standpoint, and I think a lot of the issue turns on something Casey said, right? So one of the things interesting about this case is Katsas, Childs, and Edwards. It's a 3-judge majority. Katsas, obviously a Republican, Childs, a Democrat, who also used to be a district court judge. Harry Edwards, the former chief judge, was long-serving Democratic appointee. And what I thought was the most interesting part of the case is Herridge presses 2 main points. Most of Chen's alleged damages were caused by DOD's independent decision to cut off funds to UMT, and almost all of Herridge's reporting came from sources other than Privacy Act information. And then Katza says, but most is not all. And Chen does seek damages not flowing from a loss of business after the DO severed its ties with UMT, right? So, and that, I guess I'm a little less skeptical than I heard Casey. It seemed to me, as I understood the timing, DOD did the investigation, shut off her funding, I think in 2016. And then in 2017, the story gets out, and then it puts on this public, it does implicate then this larger public issue about Chinese spies and stuff like that, as opposed to them cutting off her funds before that. And so that's why Herridge says, my reporting isn't what caused her damages. What caused her damages was the DOD's decision, not triggered by us, to cut off her funds, right? And Katsas says Herridge's arguments at most suggest that Chen is likely to recover only a small amount of damages, but that does not render her claim frivolous, right? So they said the fact that your leaking caused some harm goes to damages, but not to the Privacy Act thing, where he basically seems to focus on, there's not really much, the way they interpret the statute, there's not really a materiality kind of requirement or substantial harm requirement. And that part of it struck me. I understand the principle there, and maybe that's the way the statutory language was struck, but that part of it struck me as a little problematic, right? Which is, if her harm really, it did come from the DOD's independent decision to shut it off, not from what later happened. The later leaking strikes me as, yeah, there's a Privacy Act violation here. Yeah, I get the point that maybe it goes to damages, but it also kind of strikes me that that's the kind of thing where a court might reasonably be able to balance the public interest from forcing the reporter to disclose versus the harm to the individual. And I say that with a queasiness because I always hate balancing tests. So maybe Judge Katsas does too. So
I think in this case, though, it was the fact that the article came out in 2017 on Fox, and there were people quoted in it, like maybe one person was identified, but most were anonymous, and they were calling out the DOD for continuing to fund this university. And then a year later, the DOD seemingly, I think in response probably to the bad press, in all these Fox articles, they cut off the funding to UNT.
So it was after the reporting, not before. Oh, okay.
Yeah, and some of it was explicitly in the article saying, how could the DOD fund this? It's clearly run by, the Chinese government. So I think it really was kind of a direct response to this bad press and the leak. Yeah,
this is a good case to have mixed thoughts on, I think, for all of it, especially people who are, public interest litigators, because you have what sounds like a worthy lawsuit on one side, and then you have this reporter's privilege and First Amendment values on the other. And it's interesting that it's not in right, usually when this comes up, it is, like Todd was saying, national security kind of context I keep thinking of Bob Novak and everything that he went through, and Judith Miller and these other reporters went through in the 2000s. And some of them, went to jail because of that, because there was this leak that was investigated in all kinds of different ways about, that had to do with the run up to the Iraq War. And that was the government, the federal government doing investigations, whereas here you have a private lawsuit is really what it comes down to. And so how to weigh everything there makes it different and I think more interesting. So we're going to close with, we talked a little bit about maybe tax issues along the way there, and we're going to close with a tax issue that I had no idea existed, but it sounds to me, I have a new plan. So it sounds to me what you should do is go work for a very large financial company that is engaging in some kind of tax fraud, and then be a whistleblower for that company, and then you can retire with quite a lot of money. Although it sounds like it might take you about 20 years to get that money. And so that's the story that Bob's going to tell us about, which has a very revealing name, In Re Sealed Case.
Yeah. You stole my intro. You're so good at this. Like, I was going to say, I'm covering In Re Sealed Case, which is going to be hard to remember, but it's going to make us all sad that we did not discover Wall Street firms engaged in overseas tax fraud. So this is a case out of the D.C. Circuit from last month, written by Judge Garcia, and it is about sort of the backdrop is major Wall Street firms in the kind of early aughts, like the early 2000s, were helping foreign hedge funds save money on their U.S. taxes because foreign owners of certain investments that paid dividends were supposed to pay, a higher tax rate than domestic owners. So what these Wall Street firms would do was, I don't know, if the function was different at different firms, but you would essentially maintain the ownership of the asset for your foreign client, pay the domestic tax or whatever, the lower tax is, and true up later on whatever your client's gains would have been. And this was apparently a lucrative business, as we'll find out. The case is all about a whistleblower, somebody who worked at one of these Wall Street firms in 2003 to 2004. This guy becomes aware that, maybe this is a shady activity and what we're doing doesn't have a legitimate tax savings purpose, but rather is to shield assets from legitimate taxation. In 2005, as the opinion notes, this person leaves his Wall Street firm, and the opinion notes that he left with hundreds and perhaps thousands of documents. I don't know why it introduces that ambiguity, but it does. Leaves with a bunch of documents and goes to the IRS right away to start describing, hey, I think there's something you might want to be aware of. In 2005 through 2006, this person, I'm going to refer to him as a whistleblower because we don't know his name for sure, but the whistleblower is meeting with IRS officials and explaining how these transactions work and telling them for the first time, this kind of thing is happening. You should understand this is the way that it works. I think other firms beyond mine are engaged in this activity. And then one of the IRS officials says, hey, we have these forms that if you file them, you might be entitled to part of the recovery. If we ever get some of this substantial amount of money we're due, you might be able to get some of it. I don't know if the whistleblower knew or not, but when I read this in the opinion, it made me think of, I might be dating myself, maybe you people know about this. There's a movie called The Incredibles. It's an animated film. And there's a scene where the Incredibles are no longer superheroes, and Mr. Incredible, the dad, works at an insurance company, and he's denying a claim for a little old woman, and he feels really, really bad about it. And she is crying, and he looks around to make sure no one's hearing, no one's listening. And he tells her, all right, I want to help you, but I definitely cannot tell you to file this form with this person to make, and she ultimately gets a recovery. And as she's leaving, Mr. Incredible's boss shows up and starts yelling at him for paying another claim. So I thought of this when I read it in the opinion, but suffice it to say, our whistleblower files those forms. They're called Form 211. And on this form, you just kind of describe, who do I know? Who do I work for? What's their bad behavior? How did I come to learn about it? He files these and submits them to the IRS, and, here's nothing for a while. Unbeknownst to him, the IRS and draws in people from all across the country. They meet, they talk about this scheme, and presumably formulate some plan on how they're going to investigate it. But they don't say anything to the whistleblower about it. So he goes to the Wall Street Journal and says, hey, there's this thing going on. And in July 2007, the Journal writes a couple articles about it. And then a year later, the Senate gets interested, and the Permanent Subcommittee on Investigations has some hearings, issues a report. This was a big committee. President Obama was on it.
It was in September 2008 when there was a lot going on Wall Street-wise.
It was a busy time. Yeah. There was an election coming, and the economy was cratering. So this report gets issued. The whistleblower submits documents and information to the committee that they use a little bit in the report, but it's also a wide-ranging investigation. The hearing record is pretty crazy. We don't know who this whistleblower is, but there's a separate whistleblower from Liechtenstein who changed his name, and in the interview transcript, he's like, my name used to be X, and now I'm this other person. But he was Liechtenstein's #1 most wanted expatriate because he broke these bank secrecy laws, I think, or rules that they have there. So good reading if you want to check it out. But anyway, they have this subcommittee do the investigation. They issue reports. After that, our whistleblower goes back to the IRS and says, hey, actually, there are more people you learned about from me. I'm filing more of these forms that'll entitle me to recovery. That's 2008. After that, not much happens, but the IRS is separately pursuing tax recovery actions. They can do it kind of administratively, like the professor described, at the FTC, you can prosecute cases in front of your colleagues at the agency and you've got a great recovery. IRS can do that when they want to recover taxes, or they can go into a court and try to recover it there. They do that for a number of years after the disclosures that our whistleblower makes, and they're able to recover a lot of money. And in 2014, so from 2014 to 2019, the IRS actually starts paying out to our whistleblower his share of the recoveries. And under this statute, he's entitled to 15 to 30%. So it's that set range. You can't go below 15, can't go above 30. He gets 30% for 4 of the awards that they recover.
And that's right? Must be $20 million or something that he gets.
This dispute is about whether he's going to get 22% or 30% of the 5th award. So this company that is involved here agrees that they're being prosecuted by the IRS. They agree, hey, we'll give you the $88 million that you want, okay? So he's entitled to at least like $13 million or something like that, and up to $25 million. They decide to give him $19 million. And the way that this works at IRS, they have an Office of Whistleblower Protection, and they look at the kind of forms that he submitted, and they think, how much did he substantially contribute to the action? And they set the award between 15 and 30. They decide on 22 for reasons that'll become clear in just a moment. He finds out he's only getting the 22%. And he says, I'm not happy with that. I got 30% with all of these others. I want the $6 million. And I'm sure his lawyers did too. There's a thing you'll learn about when you start practicing. If you go into private law, there's a contingency fee recovery. So, you don't always have to pay your lawyers up front. Sometimes you can tell them the IRS owes me $6 million. And if you get it, you'll get 30% of it. So he, after the whistleblower office issues its award, you can appeal their award to the tax court. And he does that, and he goes to the tax court, and kind of the interesting thing going on in this case that you'll see in a lot of appellate cases is the standard of review. That kind of decides who wins in a lot of cases. You probably heard in constitutional law, like rational basis, strict scrutiny, that kind of thing. There are other standards of review. Here, the tax court said, we review this award for an abuse of discretion, which is, if you hear that and you're the plaintiff, you got your work cut out for you, because you got to show a mistake of law or you got to show a clearly erroneous fact finding. And what happened in the tax court is what Anthony and I see a lot in our litigation. If you're on the other side of the federal government, I have a case where we're litigating against the Department of Labor. And the administrative law judge decided that the agency did not abuse its discretion because it looked at the right statute and looked at facts that technically did exist and just, reached a conclusion. And that's what you're supposed to do. That's not an abuse. That's kind of what happens in the tax court here. Even though all of these other groups or on the other awards, you got 30%, it was okay that you got 22% here, even though basically all of the facts are the same. After you lose at the tax court, you can appeal to any U.S. Court of Appeals, and our whistleblower appeals to the D.C. Circuit, and the D.C. Circuit, in the opinion that I'm talking about, reverses the tax court here, and it kind of opens the legal discussion by saying that whole standard of review thing that I just described doesn't really matter, because whether it's abuse of discretion or de novo, which is Latin for we look at it, anew, we're going to take a fresh look at it. The tax court was wrong either way. And what it boils down to is, while the whistleblower office was trying to determine whether to set the award at 15 or 22 or 30, an analyst in that office contacted this team at an IRS office that was investigating the relevant company that's attached to this award, and found out that IRS office was already auditing this company. Now, if you heard me at the beginning, these are major Wall Street firms, big banks. So like the fact that they're under an audit might not come as a surprise. So the analyst finds out, okay, you were auditing them. Did you start auditing them because of the whistleblowers' disclosures that they made in 2005, 2006? And the office says, no, we did not start investigating them because of those disclosures. And the analyst asks, well, why did you? And the office says, well, it's because we were already auditing them. And when you audit somebody in year one, you come back and audit them in year two just to make sure whatever you agreed in audit one, they're implementing or they're fixing the errors that you found. So from those email communications, which also included emails from the IRS, the field person saying like, I'm also not the person you should probably be talking to about this because I don't have access to the files about the investigation and they're decades old. Based on that email exchange, very hazy, the whistleblower office said the IRS agents in the field did not, basically did not rely on this whistleblower's disclosures, even though the rest of the IRS admitted, we learned how these transactions worked based on what the whistleblower said to us. That was a clearly erroneous factual finding to say these IRS agents in the field did not rely on the same disclosures that basically everybody else in the IRS relied on to learn about this. So at the end of the day, the DC Circuit reversed and remanded for further proceedings. So I hate to say the whistleblower doesn't have the extra $6 million yet, but gets to live to fight another day.
Well, he's going to get what's due to him, it sounds, or at least another crack at it. So I am sorry to say we are running short on time. We've gone a little long, but any quick thoughts from our other panelists about the extraordinary way you can get wealthy by whistleblowing, it seems.
It's funny, when I read this case, I put on my law and economics hat, and I thought, to some extent, the IRS should have their incentives aligned to give people appropriate awards, to get future people to come forward, right? And so that was one thought I had. But one of the other thoughts I had is, how did they come up with 22%, right? Which is, if he didn't actually give the tip, why would they not give him 15 or something, right? Where did this number come from? Just split the difference, I guess?
So the tax court opinion suggests it's kind of an anchoring, like a psychological anchoring thing. They just have like 15 or 22 or 30.
Right. So it's like halfway in between 15
Yeah,
and
not
30.
really an explanation for it.
That's what it looked like, yeah.
Because I don't know much about IRS whistleblower protections or awards, but I'm wondering, the fact that the IRS guys here thought that they could just get away with this by presenting some really vague emails saying basically nothing at all, and that's why we went with the 22%. I wonder, and I don't know that there's any connection here, but since Loeb or Bright, I wonder if just kind of the mentality of courts automatically, reflexively deferring to agencies' positions or interpretations maybe somehow influenced it here, where the court was like, wait, I independently have to judge the situation, and this is ridiculous.
I think that's definitely, there's something to that. Like, it's in the water now that you're a little bit more suspicious of administrative agencies. Anthony mentioned I'm the co-director of our zoning project. We meet a lot of state court judges who, like, the only zoning case they know is Euclid. And so they hear zoning, they're like, I'm pretty sure the government is supposed to win, and that's something that we are trying to change, that Loeb or Bright, I think you're right, has.
And there is this funny footnote in the case where they say the government tried to introduce evidence at oral argument that they previously had, and they're like, no, too late, you can't gin up our arguments.
That doesn't work anymore.
Well, I'd like to thank our panelists for coming here today and thank the chapter again for inviting us. And as for all our listeners, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.